meeting of the Statutory Licensing Committee. This meeting is being broadcast live over the internet and will be available to view online and now in the future. May I remind members that as per statutory guidance made under Section 4 of the Local Government Wales Measure 2011 and our formally adopted hybrid meeting policy, any member attending a meeting remotely must be able to be seen and heard by the members and officers who are attending the meeting, as well as by members of the public viewing the meeting. So can I ask that you all please use your cameras for the duration of the meeting. We welcome the use of the Welsh language in meetings. I've had no requests for people to speak Welsh today, so this meeting will be conducted in English only. Members in the chamber, please be aware that we are all on camera and that you may be visible on screen when people around you are speaking. And please remember to speak clearly into your microphone. Members participating remotely, can you please refrain from using the chat function and instead use the raised hand icon to indicate when you want to speak. Please remember to keep your microphone muted when you are not talking. Now moving on to the agenda. Chris, do we have any apologies?
No apologies today, Chair.
Anybody else got anything? No. Item 2 then, declarations of interest. Members, do you have any interest to declare?
No.
Councillor Coles?
Thank you, Chair. Just in relation to item number 4, one of the applicants on a minutes of a previous licensing hearing is Blenavon Town Council. So just to claim a personal interest, I'm a member of Blenavon Town Council, Chair. Thank you.
Okay, that'll be noted. Thank you for that. Right. No one else? Before we move on to the next item, which are the item 3, the minutes of the last meeting, which was on the 28th of 11/2023, and that's page 5 to 8. Could you possibly state whether you have anything to raise in relation to them minutes? If not, I will take them as approved. Was everybody in agreement with that? Yeah. Yep. Great, thank you very much. Right, we then go on to item 4, which is the minutes of the previous licensing hearings, page 9 to 48. Do any of the officers want to say on any of that, or do we move forward? Right. Members, are you happy to note the minutes? Because there are quite a few there, isn't there? Yeah. Yeah. Right. If we move on to item 5 then, approval of proposed fees 24-25. Gambling and film classifications, and that's on page 49 to page 62. Could you please deliver the report? Was it Robin?
It's myself, Chair. Thank you. Good morning, members. The purpose of the first report for Statutory Licensing Committee this morning is to inform members of the proposed licence fees for 24-25 in respect of gambling and film classification, which requires the approval of the Statutory Licensing Committee. Certain licence fees are deemed to be non-statutory in that local authorities can determine what or whether to charge. The calculated fees are intended to be a fair reflection of the actual costs of administering and enforcing each licence, in much the same way as everyone would expect to pay a reasonable price for a service they receive. However, it is not possible to achieve full cost recovery in terms of overall licensing functions because some activities do not relate directly to the administration and enforcement of licences. The calculated costs are based on budgeted salary costs for 24-25 in line with the Council's medium-term service and financial plan. Central services apportionments and direct costs such as IT systems, are based on the 22-23 actual costs or confirmed costs. Under the Constitution, the setting of fees levied for licences falls to the Licensing Committee for determination. Section 4 of the report sets out the general fee setting principles, and fees are reviewed on an annual basis. For each licence type, there are 3 main elements which are calculated. Those are the underpinning costs, the specific licence steps relating to each type of licence, from initial advice through to the administration and approval of the licence, and the hourly operational costs to the authority for each officer. The actual cost of each underpinning activity and specific licence step is calculated using the hourly rate, thereby ensuring that each licence applicant pays a fair licence fee depending on the time taken to process and deliver each type of licence. Local authorities are specifically precluded from making a profit, using income generated from one type of licence to subsidise other licences, cannot benchmark fees against those charged by neighbouring authorities, and cannot use fees for other purposes. Section 4.2 of the report refers to the proposed fees for gambling licences for the 24-25 period. The proposed licence fees are attached at Appendix 1, and a comparison table with neighbouring authorities is attached at Appendix 2. Section 4.3 of the report refers to film classifications. Under the Licensing Act 2003, local authorities may be asked to classify films for viewing. This authority has never received a request for the classification of a film, but other authorities in Wales have received such requests, and it therefore seems prudent to have a fee structure in place. The calculated fees are based on estimated timings, allowing for different lengths and types of film. However, these would need to be reviewed on the basis of experience should an application be received. The proposed licence fees for film classifications are attached at Appendix 3. In regard to our neighbouring authorities, a comparison with fees set by Blaenau Gwent County Borough Council are attached at Appendix 4. In preparing this report, officers have worked with the finance team to establish our officer hourly costs, and the report has been seen and approved by finance and legal prior to submission to members. Members are therefore asked to approve the proposed statutory licensing fees falling to this committee for determination, or should they not approve any of the proposed fees as stated, state the reasons for not approving the fees and agree an alternative. Thank you, Chair. That's my report.
Any members got any questions or comments you would like to see to the officers? Anybody here? No. No. If nobody's got anything, then are we happy to endorse the recommendations? Are we all in agreement?
Yeah.
Yeah. Anybody doesn't? Right, thank you. We'll then move on to item 6 then, which is review of the Council's statement of gambling principles, which is page 63 to 132, which is now Robin's. Thank you.
Thank you, Chair. So Section 349 of the Gambling Act 2005 requires that a licensing authority shall, before each successive period of 3 years, prepare a statement of the principles that they propose to apply and exercise in their functions under the Act during that period, and publish the statement. The Gambling Commission's guidance to local authorities, it was last published in April 2021, that is statutory guidance published under the Gambling Act 2005, explains that the statement of policy forms the licensing authority's mandate for managing local gambling provisions and sets out how the licensing authority views the local risk environment and therefore its expectations in relation to operators with premises in the locality. The licensing authority policy statement regulations that are made under the Gambling Act 2005 provide that the statement must include an introductory section at or near the beginning that summarises the matters dealt with within the statement, along with a description of the geographical area in respect of which the authority exercises functions under the Act. There must also be a list of persons whom the authority has consulted with in preparing the statement. The regulations then say that there must be sections setting out the principles that will be applied by the licensing authority in designating a body which is competent to advise on matters relating to the protection of children from harm, determining whether a person is an interested party in relation to a premises licence or an application for or in respect of a premises licence, exercising its functions relating to the exchange of information between the authority and the Gambling Commission, the police, enforcement officers of other licensing authorities, HMRC, first-tier tribunals will hear appeals against decisions made by the Gambling Commission and also the Secretary of State. And the policy must also include a section regarding the exercise of its functions with respect to the inspection of premises and to instigating criminal proceedings in respect of offences for which the authority is the enforcing body. The current statement of policy is attached to the report as Appendix 1, and it includes all the required information that's detailed above in the report. But it must now be reviewed and a new policy prepared for the next three-year period that will begin on the 31st of January 2025. Section 349 of the Act also provides that in preparing a revision of the Statement of Principles, the authority shall consult with the Chief Officer of Police for the authority's area, one or more persons who appear to the authority to represent the interests of persons carrying on gambling businesses in the authority's area, and also one or more persons who appear to the authority to represent the interests of persons who are likely to be affected by the exercise of the authority's functions under the Act. The Gambling Commission guidance explains that that is the consultation is deliberately wide, as it allows licensing authorities to undertake a comprehensive consultation exercise with anyone who may be affected by or otherwise have an interest in this statement of policy. The guidance further provides that it is a matter for licensing authorities to develop their own consultation practices, including the methods of consultation and who they consider it necessary to consult with, which might include consultation with relevant local groups, businesses and responsible authorities. For the next review of the policy, it's proposed that the consultation process should follow a similar format to previous years, and that a formal public consultation on a draft policy should take place over a 12-week period. However, prior to the draft being prepared and considered by the committee at probably its next meeting, it's proposed to seek views on the existing policy from the Council's responsible authorities, and those include the Gambling Commission and the Chief Officer of Police, and also the holders of existing licences, permits and registrations issued by the Council under the Act. And that will give the opportunity for those with responsibility for and whose businesses or organisations are affected by the gambling regulatory regime to highlight any areas of the current policy that they feel need to be addressed when a draft revision is prepared. So that could be changes to existing policies within the statement, or any new areas that they feel should be concluded within the policy. It's proposed that the initial consultation with the responsible authorities and existing licence holders and registration and permit holders would take place over a short 8-week window, because it will be targeted and will be followed by a wider public consultation. And that would also allow the Council to meet its deadline for approving the adoption of the revised policy, which must come into effect no later than the 31st of January 2025. So a proposed timetable for the review of the Statement of Principles is set out in paragraph 4.5 of the report, and it begins with the committee considering the proposed timescale and consultation process today, the 8-week consultation process. The results of that will come back before the committee in May with a draft policy for consideration. If that's approved, then there'll be a subsequent 12-week public consultation process, and then the results of that and a final draft revision of the policy will come back before the committee in September, October time at a meeting held then, before it go on to full council for approval. So this isn't a policy that the committee can fully adopt. It has to be done by full council. And obviously, factoring that in, we've got a timetable that will take us almost 12 months to complete. So as I said, the responses received during the initial consultation process that's proposed will be reported back to the committee as per stage 2 in the table above. And the committee will be asked then to consider a draft policy, which may be amended by members as deemed appropriate, and approve formal public consultation on that draft policy. So that's the current situation. The Statement of Principles must be reviewed and a new statement adopted and in place by the 31st of January next year. So the committee, as per the recommendations, are asked to approve the proposed timetable for the review of the Statement of Gambling Principles as set out in paragraph 4.5 of the report, and also to agree for consultation with the responsible authorities and the holders of existing licences, permits and registrations issued by the Council under the Gambling Act 2005 to be carried out to seek their views on the current Statement of Gambling Principles. That's the report, Chair. Thank you.
Thank you, Robin, for that report. Has any members got any questions or comments they would like to state to Robin? No? Are we happy to agree the recommendation? Yeah. Anybody doesn't? That's great, thank you for that. Right. The next one is item 7, is date of the next meeting. For your information, it's on the 9th of May again at 2024. Are we all right with that, Chris? Yeah. Because we need to move on to item 8, which is exclusion of press and public. Do members agree to the exclusion of the press and public from the meeting as presentations and meeting papers and not for publication? Because in accordance with paragraphs 12 and 14 of Part 4 of Schedule 12A of the Local Government Act 1972, as amended by the Access to Information Variant Order Wales 2007, it contains information about a particular individual and information relating to the financial and business affairs of a particular person, including the council, and in all the circumstances of the case, the public interest in maintaining the exemption outweighs the public interest in disclosing the information. Have we all agreed with that?